Hey guys, good morning, good afternoon, good evening. I was just getting to my computer. I was looking at whatever news stories were happening for the day, and I don't know what's been going on lately, but it seems like there's just been so many stories, like all of these different arrests. We have the bricks and minifig saga going on. I just read this morning about a woman who got arrested for commenting on contaminated water on social media. And like just it just seems like so much is going on. And then I get tagged in a post by Kyle Sharkey, so thank you for that for letting me know. But we had a decision come down from the New Hampshire Supreme Court. So this is the state court of New Hampshire overturning Adam Montgomery's second-degree murder conviction. So, right out the gate, I do want to jump right down to the bottom of this order. And out the gate, it's very worth noting, I think, that his convictions for second-degree assault, for falsifying physical evidence, for the witness tampering, and abuse of the corpse, all of those other convictions are affirmed. They still stand. So what we're talking about today is just a reversal on the second-degree murder count. So it's not like he's just gonna be released and. Other than that, I think the argument, the reason for this being overturned is something that is really worth looking at. It looks like the prosecution wanted to have its cake and eat it too. So, what exactly happened? All right, so if we go back in time to when this murder actually occurred, and then we look at the joinder of the assault charge that was included in this case, they're separated in time and place. And yet they were tried together, and that's called a joinder. So this joinder of what happened in July 2019 with the assault charge and the homicide, the murder, separated in time, and this is really the heart of the issue on this appeal and why the state Supreme Court decided, look, bringing these two issues in at trial together created unfair prejudice to the defendant. He did not have a fair trial. So we're going to look at their arguments here, and if you're new to my channel, something I always want to know is surely prosecutors had to be aware that this could cause a risk on appeal. Why didn't they try to avoid this issue? So here we go, guys. Let's get you guys on the screen. See what you guys are doing. I hope you guys are all doing well. And here we go. So this was argued on October 15th, 2025. If we have time, I have the oral arguments. They're like 30 minutes long. It's kind of short. So if you guys are interested in watching those oral arguments after we get through the motion or the opinion, let me know. We can do that. And then obviously the opinion issued today. That's why we're here. So we've got John Formella, the Attorney General, and Anthony J. Galdieri, Solicitor General. They said that Sam Gagne here, he did the oral arguments and the brief for the state. And then we have Pamela Phelan, who is an appellate defender, right? So she's assigned. This isn't like someone didn't pay big bucks for this, of Concord on the brief and orally for the defendant. And then we have Justice Gould writing this opinion. So the defendant, Adam Montgomery, appeals his convictions following a jury trial in Superior Court of second-degree murder, second-degree assault, falsifying physical evidence, witness tampering, and abuse of the corpse. They affirm in part, as we discussed, on all of the other counts besides the murder. Now, the background here. They say the jury could have found the following facts. The defendant was the biological father of the victim, Harmony Montgomery. On February 2019, the victim went to live with the defendant and his wife, Kayla Montgomery, at the defendant's grandmother's home in Manchester. In July 2019, when the first charged offense occurred, the victim was 5 years old. The other occupants of the home at that time included the defendant's uncle and the two biological children of the defendant and Kayla. Both of those children were younger than the victim. The defendant's uncle returned home in July from a 3-week trip and saw the victim in the kitchen with a black eye. The uncle asked the victim what she'd done, and the defendant answered, "She didn't do anything. I bashed her around the effing house, the fucking house. We'll just say it, because that's what's in the transcript." The uncle testified that the defendant said he put the victim in charge to watch her 5-month-old brother while the defendant used the bathroom, and when the defendant returned, he found the victim with her hands over the baby's mouth and his lips are supposedly blue. On November 27th, 2019, the defendant's family was evicted from the home in Manchester. The defendant, Kayla, and the 3 children, so all of them, begin living in their car, which they parked at a friend's apartment complex in Manchester. Although the victim was toilet trained before she was 3 years old, she started to have accidents once the family began living in the car. So sad. Like, it's just stress. When the victim had an accident, the defendant became angry and would hit her in the face or on her leg or hand. The defendant became angrier and more accidents the victim had and would then hit her repeatedly. On December 7th, 2019, and by the way, guys, the way we're reading this, like, they are stating what the jury could have found, but me personally, I'm getting the impression that the Supreme Court does feel that this very sufficient evidence on the record that this likely was what was going on and that the jury was correct in their assessment. Um, but yet there's going to be a problem that is so egregious that it warrants a reversal. That's the impression I'm getting as I read the way they're writing this. So they say on December 7th, 2019, the victim had an accident early in the morning and the defendant repeatedly punched her in the head. Later that morning, the family drove to a methadone clinic where Kayla and the defendant took turns going inside while the other stayed in the car with the children. When the defendant returned to the car, he realized that the victim had another accident and started yelling at her and hitting her in the head repeatedly. From the methadone clinic, the defendant drove the family to Burger King. While they were driving, the victim was in the backseat crying and making a strange moaning-like noise. The defendant told the victim to shut up, and at each red light at which they stopped, the defendant reached back and repeatedly punched the victim in the head. The defendant stopped hitting the victim when they got to Burger King. With the final punch, he said in a scared voice that he felt something and thought he really hurt her this time. Later that day, the family's car broke down at a traffic light and they had to abandon it. As the defendant and Kayla were getting the children out of the car, the victim did not respond and they realized that she died. The defendant got a duffel bag from the trunk, put the victim's body in it, and brought it back to the friend's apartment complex, where the defendant put it in a snowbank. Following the loss of their car, the family stayed in a friend's car, then with Kayla's mother, and then from December 30th through February 20th at the family's in transition shelter, which they might just call this FIT from now on, in Manchester. The defendant brought the duffel bag containing the victim's body to each place where they stayed. At FIT, the defendant put the duffel bag in the ceiling vent in their room. When the victim's body began to smell and leak fluid, the defendant put the body into garbage bags, which he then stuffed into a diaper bag. The defendant worked at a restaurant at the time and would store the bag in the restaurant's freezer while he was there. The family moved from FIT to an apartment in Manchester. There, the defendant kept the victim's body in the apartment freezer. The defendant began discussing getting rid of the victim's body and devised a plan to dismember her and use lime to hide the smell, which he believed would hasten decomposition of the body. On February 26th, the defendant withdrew cash from an ATM and purchased lime, an angle grinder, a blade, and a battery. At some point thereafter, the defendant thawed the victim's body in the bathtub at the apartment and had Kayla help remove the victim's clothing. The defendant had a large bag of lime and spent several hours in the bathroom with the victim's body. When the defendant was finished, he put the victim's body back in the diaper bag and put the bag back in the freezer. On March 3rd, the defendant and Kayla stayed in an Econo lounge with a friend of the defendant and the friend's girlfriend. The defendant had asked the friend to rent a U-Haul for him because he needed to move stuff. That evening, the friend arranged the rental. Back at the hotel, the friend and the defendant went outside to smoke a cigarette, and the defendant began pacing back and forth, repeating, "I fucked up." The defendant left the hotel in the U-Haul in the middle of the night. He took the diaper bag containing the victim's body with him and returned without it, telling Kayla he got rid of her. And a lot of this is coming from Kayla's testimony. After the defendant killed the victim, he began telling police that he had returned the victim to her mother in Massachusetts after Thanksgiving in 2019. The victim's mother, however, had not seen the victim since April of 2019. Thereafter, the victim's mother tried to contact the defendant and Kayla, but was unsuccessful. By December 2021, the victim's mother had reached out to state and local agencies, and officials tried to find her daughter. This is so far gone. What are we doing? At that point in time, law enforcement became involved in the search for the victim. The defendant was indicted on one count of each of the following offenses: second-degree murder, second-degree assault for having struck the victim in July of 2019, falsifying physical evidence, and witness tampering. He was also charged by criminal complaint with abuse of a corpse. the defendant filed an assented to motion to join the charges for trial, which the court granted. Subsequently, however, the defendant moved to sever the second-degree assault charge from the other charges after receiving a Zwicker letter. All right, so this is going to, the reason this is important is this is a catalyst, this is new information. And so even though we're laying out the procedure here, what happened, initially, Adam Montgomery, his team, they're like, yep, we agree, join these charges for trial. And that's, the court's like, okay, we're going to do that. So then there's a change. Something happens, and it's specifically, it's this Zwicker letter, and there's a footnote. They say, while based loosely on State v. Zwicker, which is why we're calling this letter this name, the term has come to have a colloquial meaning in New Hampshire criminal practice. It refers in this instance to the state's written disclosure of newly discovered evidence that was not included in the state's disclosures under New Hampshire Rule of Criminal Procedure 12b1. So it's new discovery that wasn't previously given to the defense. So they turn over this discovery, and it says it's imparting information from Kayla Montgomery that marks a substantial departure from her prior statements. So co-defendant, or I don't know if she was actually, I actually don't know procedurally if she was on the very same indictment. But she was also charged, she testified against Adam Montgomery, but her statements are changing, and she's a critical witness. So they get this Zwicker letter that, all right, we've got the substantial difference in what she's saying now compared to what she was saying previously. And the defendant was like, look, I don't want to do this joint trial anymore, like this joinder, where we're just combining all of these charges together. I don't want them all to be in this trial anymore, because whatever Kayla's saying in this letter, maybe it's changing my trial strategy, whatever it is. But the court denied this request to then separate the charges for two different trials. The defendant also filed a number of motions in limine, which, as relevant to this appeal, included motions to exclude: one, evidence that he prevented the victim's mother from seeing the victim, so actual mom of Harmony; two, evidence of his abuse and neglect of the victim other than the charged conduct; and three, evidence of his encounter with the police on December 31st, 2021. The trial court denied the defendant's motion with respect to interference with the victim's mother's attempt to see the victim. With respect to the remaining two categories of challenged evidence, each motion was granted in part and denied in part. While the court limited what the state could introduce, it declined to exclude all of the evidence in each challenged category. So there's additional issues that he's raising would prejudice him, and he didn't win all these motions in limine, which might not be surprising and might not have been an issue if it wasn't going to be compounded with this issue with the joinder. So then the defendant was tried before a jury in February of 2024. In his opening statement, the defendant's counsel told the jury that it can and should find the defendant guilty of falsifying physical evidence and abuse of a corpse. He asserted, however, that the defendant committed those crimes to protect Kayla, who was the last person to see the victim alive and know how she died. He contended that the victim did not die during the day on December 7th, but during the previous night while the defendant was running around trying to make money to get them out of their situation. And Kayla was alone in the car with the children. He told the jury that it would not hear truthful testimony from Kayla, and that the only reason she has to lie and point the finger at the defendant is because the truth points the finger at her. The jury returned guilty verdict on all charges, and then this appeal followed. So then we've got the analysis, right? So this is the court laying out, I mean, this paragraph here is kind of where we get something that's like, oh, it's not all about the evidence supporting Adam's guilt, but it's showing that even though the defense tried to make a certain argument, the jury still came back with a verdict of guilty on everything. On everything. So, and hey guys, how's the chat doing? I see Shell's shocked saying, I hate to be mad, but I am. Damned constitutional rights and such. It's a valid feeling. It's a valid feeling. Okay, and then Nina says Kayla was not charged. She had immunity. So there, you know what? Even worse. Even worse. Because that puts greater weight behind this argument, if you ask me. And whether that weight actually points to she has immunity and is lying because she has immunity. That might not necessarily be the case. But when someone just gets immunity, they're in the clear. It's a big credibility issue. Big credibility issue. And then 16 months for perjury. Or 18 months maybe. But, either way, like way 16, 18, like that's the difference between those two. Totally negligible in my mind compared to what you could be facing if you were the one actually charged. Like, so let's see. They're going to talk about the severance first. They've got the defendant first argues that the trial court erred in denying his request to sever the second-degree assault charges from the other charges. The trial court's decision to sever or to join or sever charges is discretionary. They do have some range of choice. We will affirm its ruling unless the decision constitutes an unsuitable exercise of discretion. To succeed on appeal, the defendant must demonstrate that the ruling was clearly untenable or unreasonable to the prejudice of his case. So it's on the defendant. It's their burden. New Hampshire rules govern the joinder of criminal offenses and distinguishes between related and unrelated charges. It provides that if a defendant is charged with 2 or more related offenses, either party may move for joinder of such charges. The trial judge shall join the charges for trial unless the trial judge determines that joinder is not in the best interest of justice. By contrast, unrelated charges may be joined only upon written motion of the defendant or with the defendant's written consent. So this is important, right? The determination, there's kind of 2 steps here. Do we think that these charges are related? Do we think that they're unrelated? And whatever bucket we decide, the judge decides to put those in, then there's a different standard for deciding whether or not to do a joinder. And if you think that these 2 charges are unrelated, then we need a written motion from the defendant and the defendant's written consent. And upon a showing that the failure to try the charges together would constitute harassment or unduly consume the time or resources of the parties. So there's a different process there. So they say the defendant argues that the trial court erred in finding that the charges were related for the purposes of the rule we just read. Alternatively, he argues that even if the charges were related, the court should have severed them in the interest of justice. So on appeal, what was her name? Miss Pamela. I remember the first name. Pamela Phelan. So Pamela Phelan made sure we argue both. So as a threshold matter, we note that neither party argues that the best interest of justice prong of the joinder analysis must be based on the evidence before the trial court at the time of its pretrial ruling. Accordingly, we do not confine our best interest inquiry to the pretrial record. And they cite here C.F. Brown, which says, considering the defendant's arguments that were based in part on trial events, where the state did not contest whether trial events may be relevant to our review of the trial court's pretrial decision on joinder. So they've got some case law that lets them preclude that if it's not raised. Under the best interest of justice standard, charges should be tried separately whenever it is deemed appropriate to promote a fair determination of the defendant's guilt or innocence. So in essence, when conducting a single trial would jeopardize the defendant's right to a fair trial. And this is State v. Rivera with a holding, they quote here, that in making a best interest of justice determination, trial courts must evaluate that whether, in the view of the number of offenses charged and the complexity of the evidence to be offered, the trier of fact, the jury, will be able to distinguish the evidence and apply the law intelligently to each offense. The best interest of justice determination may also entail considerations of other factors, including whether some charges are likely to unusually inflame the jury against the defendant. The evidence, and you guys, reading through the text above, you saw me going, like, that's me getting inflamed. The evidence in support of some offenses is weak, while the proof of others is strong. The defendant's available defenses for different crimes are inconsistent, or the defendant wishes to testify as to one offense, but not as to others. So those are some of the reasons that you might consider a severance in the best interest of justice. So the defendant argues that joining the charges gave rise to a risk that the jury would use evidence of the July assault for an improper propensity purpose when considering the second-degree murder charge. He notes that Kayla's testimony provided the only direct evidence that he fatally struck the victim and asserts that Kayla had significant credibility deficits. Specifically, and this is just, I just feel like this scenario, like just giving one person, and there's a possibility that both of these parties were abusive at some point. And so if you give immunity to one party, like the way you put everything in the other person's bucket, I just feel like you always create this risk on appeal. And yet it's just over and over and over. And maybe it's just the types of cases that I look at, because I do look at a lot of cases where there's like, oh, well, we're going to have one person get this sweetheart plea deal and we're just going to go after the other person. And then it turns into this hot mess where there's these credibility issues. Someone gets a perjury issue going, and it's like, what are we doing? And then we end up here. So they say specifically, he contends that evidence undermining Kayla's credibility included her felony perjury convictions for lying to the grand jury. And how do you contest that? You can't contest a perjury conviction and try to say, oh, she has no history of dishonesty. Like, this is as formal as you can get. On the books, she's a liar. So she lies to the grand jury, which is, a very, very significant stage in a criminal proceeding where you'd probably have a very high interest in lying if you yourself bared some responsibility, or maybe even full responsibility. Who knows? So yeah, not only was it just perjury in general, but it's related to the grand jury in this matter. So in her prior criminal history, her other criminal conduct that the state agreed not to prosecute her for in exchange for her testimony. So additional benefits conferred to Kayla. Like, why do we do this? Why do we do this? As well as numerous self-serving and inconsistent statements about what happened in December 2019 and thereafter. So by contrast, the defendant argues the state's case on the July 2019 charge was strong and rested on testimony from several witnesses without such credibility issues. The defendant contends, because the charges involve the allegations that the defendant struck the victim with his fist at different times, places, and contexts, there was a substantial risk that a jury hearing the strength of the state's case on the July 2019 charge would draw the improper inference that he similarly struck her in December and thus dismiss any doubts it might have as to his guilt on the homicide charge. We agree that the state's case on the second-degree assault charge was strong. 3 witnesses testified to observing the victim with the black eye in July of 2019. 4 witnesses, including 2 who observed the victim's black eye, testified that the defendant admitted striking the victim. Although 2 of the admissions were made near the time of the assault and 2 were made years later, each witness testified to a consistent explanation given by the defendant, that he hit the victim because he saw her with her hand over the baby's mouth, suffocating him. As to the homicide charge, only Kayla's testimony directly implicated the defendant in the victim's death. The state disputes, however, that the evidence on that charge was weak. So the state's like, it seems like the state might be the only one that thinks there's a weakness here. The state disputes, however, that the evidence on that charge is weak, arguing that so much of what Kayla said was corroborated by physical evidence and that it was easy to credit the parts of her testimony that lacked such corroboration. Specifically, the state contends, so this is why they say, like, Kayla's credible. They say that Kayla's testimony that the defendant stored, or at least credible on the parts that matter. They say that Kayla's testimony that the defendant stored the victim's body in the ceiling of their room at FIT was corroborated by DNA and fingerprint evidence taken from that ceiling. 2, Kayla's testimony that the defendant stored the bag containing the victim's body in the freezer at work was corroborated by 2 of the defendant's coworkers who testified that they saw the defendant entering or leaving the restaurant's walk-in cooler with the bag. 3, Kayla's testimony that the defendant planned to dismember the victim's body. So far, just going to pause real quick, but so far these are things that would relate to post-death. And his trial strategy, Adam Montgomery's trial strategy, was like, I did try to cover up the physical evidence and abuse the corpse. So the state is pointing to things like our case for Adam Montgomery committing the actual murder is strong because the evidence about tampering or the physical evidence is strong. And I'm not sure that that's exactly a direct correlation, although it can be. Can be. So then Kayla's testimony that the defendant planned to dismember the victim's body and accelerate its decay with lime was corroborated by evidence that they had this $500 cash withdrawal from Kayla's joint bank account 22 minutes before a nearly $400 cash purchase of items, including a bag of lime and an angle grinder, was made at a nearby Home Depot. For Kayla's testimony that on the night she, the defendant's friend, and the friend's girlfriend stayed at an Econo Lodge, the defendant used a U-Haul to dispose of the victim's body, and that was corroborated by testimony of the friend, the girlfriend, and the person who rented the U-Haul. So Kayla's testimony on these post-death incidents, it can be backed up by purchases, it can be backed up by other witnesses, and then what do we have the New Hampshire Supreme Court say here? This evidence, however, I can already tell where we're going, supports only Kayla's testimony about the defendant's actions after the victim's death. It does not corroborate Kayla's testimony that the defendant killed the victim on December 7th by repeatedly punching her in the head. It is also not consistent with the defendant's theory of defense, namely that Kayla caused the... It's also not inconsistent, namely that Kayla caused the victim's death and the defendant helped her cover up her crime. So again, that's apparently he came out the gate saying, look, I did that, but I didn't do that. So as additional evidence supporting Kayla's testimony that the defendant, rather than she, killed the victim, the state cites the defendant's friend's testimony that the defendant paced outside the Econo Lodge, repeating, I fucked up. And another friend's testimony that in 2021, the defendant told her that he hated the victim right to his core. Because she reminded him of her mother. His core? Oh, you mean, okay, never mind. I read that wrong. Adam hates to his core. I was like, the victim was a baby girl. So, but I misread that. This evidence does support the proposition that the defendant displayed a consciousness of guilt for something he had done, and that more than a year after the victim's death, the defendant had profound animus towards the victim. It does not, however, corroborate Kayla's account of the victim's death. As compared to the evidence of multiple disinterested witnesses substantiating the July assault, the evidence of the December 7th, 2019 fatal attack is substantially weaker. And this right here is so important. Why? Because if, the state was probably aware of everything that they're arguing in appeal before they took it to trial, otherwise they wouldn't have been admitting and arguing these things at trial. They likely had the same concern as what the New Hampshire Supreme Court is stating their perception of the strength of the evidence is here. Hey, look, your evidence of this December 17th, 2019 murder is weak. So circle back. How do you patch that up if the murder charge you want to bring against somebody is weak? Well, we have really strong things that show that months prior, separate incident, he's definitively this bad person who has punched this child. Right? So this is a very telling sentence because it's likely something that the state was thinking in terms of the strength of their own case while they decided how to prosecute it. So then we therefore conclude that this disparity created a significant risk that the jury would rely on the strength of the evidence that the defendant struck the victim in anger in July to conclude that, as Kayla testified, he similarly and fatally struck the victim in December. And they cite here Brown, which holds that the state may gain an unfair advantage if a weak case is joined with a strong case. The joint trial of offenses creates a significant risk that the jury will convict a defendant upon the weight of the accusations or upon the accumulated effect of the evidence. So basically, we'll convict you on the strength of the other thing and just transfer it over to this different instance. And that's really not what the point of a trial is, right? You're supposed to present your case and prove the elements of a crime as charged for each count beyond a reasonable doubt. It should not be because it's so strong on one count It must have done that other thing too. So, but as humans, it's difficult. It's difficult to separate the two once you have knowledge of the other, which is exactly what makes it prejudicial. So, Hells, this is one of those tough cases. This is the example of like, and that's why I want to frame it and like underscore, like, I just don't, you cannot convince me that the state didn't know this was a risk. But it's a risk, in my opinion, it's a risk that they chose to take because of this. They knew that the evidence for the December 7th, the homicide, was much weaker. Right? It's, you can't tell me they didn't know that this was going to be a risk on appeal. And we didn't even get to the most interesting argument. So typically when I see something is filed, I didn't read what we've read together so far in the stream yet, right? This is a blind read so far. When I see an opinion, I quickly go to a certain part below to see exactly the reasoning on the issue that they decide warrants a reversal, right? Once I see that there's a reversal, and then I'm like, all right, I'm either going to read the whole thing and write up something about it, or I'm going to share this bit that I just read and we're going to do a stream and we're going to read the whole thing together, and I'm going to wait to read it with you guys. So the stuff above this I have not read yet, but we still haven't gotten to the part that I sneak peeked at that is just like, it's just so stupid. It's just so stupid. And I don't know. I don't know. I think a jury would have convicted. Put a 1 in the chat if you think, say this assault was not part of the trial. Because it's really that's the issue, joining that assault charge with everything else. But, you know, the cover-ups, we're going to make these purchases. He's saying, I fucked up. And whatever they present about the time frame for this, we're at the methadone clinic and you go in and then you come back out and there's this, you were in the car around that time frame and we think the time of death occurred. If we do not have that assault, put a 1 in the chat if you think a jury still would convict because they heard this, you're covering it up, you're dismembering the body. You were there that day, you had the opportunity. Like, you guys look messy. This is like, and put it 2 if you think, nope, I think very good chance he would have been acquitted, at least on the murder. Let's not add in like the extra. Maybe he would be convicted on the cover up and not the murder. Let's not get complicated. Just 2 if you think he would have been acquitted of the murder if this assault didn't come in. Or put a 1 if you think the jury would have convicted him anyway, likely. Because I think when you tell a jury someone's trying to cover something up, I think it's very, very difficult to say, like, look, it was only the cover up, though. Only the cover up that I was involved in. I think that's a very, very hard sell. Unless you've really got, like, some type of alibi for the time of the crime that's strong enough. Like, credible witnesses that say you were with them. I don't know. So, yeah, I think a lot of 1s. A lot of 1s. A lot of 1s. Aaron says jurors tend to convict the unlikable, so I'm going with 1, but I don't agree. And I think the strength is less. I agree that the strength, the likelihood, like adding in this assault charge helps us seal the deal. But did the state really need to do that? Sharon says, like, yeah, the Brian, that was this year. And then I'm also thinking, do you guys remember the Megan Jackson trial in Horry County in South Carolina? She was like a body transporter, and she had her like affair partner was the coroner, Christopher Dantel. And he ended up taking a plea and saying, like, look, I only helped after the fact, but I didn't shoot her ex. She just had me in a van driving with her and she jumped out of the car and shot him. And that was a whole mess of a case. Yeah, I do like Michael here adding in a 3. You can always do a write-in. You can always do a write-in. Says I would have to listen to all the evidence. Of course. And to be fair, I think a lot of people who just voted for the simplicity would agree. You know? Ah, cool. Oh my gosh, this is so cool. Shout out to Kelly. Kelly says, voting 1, I spoke to these jurors in person at his sentencing. That is awesome, awesome, Kelly. The abuse had nothing to do with the murder conviction. Yeah, this is such great insight. So I'm glad, we got to do the poll as just food for thought, and then look at this. Look at this. And again, if you're jumping in late, by the way, you guys, this is only the murder conviction that was overturned. All of his other convictions are affirmed. So he's not just gonna like get out of jail, although I'm sure he'll be retried on this count. But let's say the murder conviction is off the table. He is acquitted of it at a retrial. I have no doubt that the state's gonna retry. If it's gone for good, then this sentence would reduce, I think, pretty significantly, because he had like 56 years as his sentence, right? I think we'd see a reduction of the sentence, but it's not like his sentence would just go away. There's still significant time attached to what he's convicted of. So, yeah, this is so cool. Thank you so much, Kelly. And let's see. Hey, it's Ariel says, so all of the jurors just believed Kayla? I mean, I think that consciousness of guilt type evidence is very compelling. So it might be, sure, Kayla said that he's the one that did it, but it could also be you have these 2 other individuals, the friends at the hotel, saying like he was like really going through it, saying he messed up. So I think that can be very, very compelling evidence. Even though, again, like, I think the weight on someone's chest of like, especially if that's his daughter, right? Because Kayla's not the daughter of the mother of Harmony. Right? So someone's saying they messed up. Maybe the defense attorney tried to argue at trial. Look, he's feeling a burden that any parent would feel if their child died. What could I have done differently? I left my child with somebody who failed to care for her. Right? So maybe you could argue that that type of grief, I messed up, is real grief, but not directly related to guilt because you're the one that actually killed a child. Right? So I think there's arguments there, but I think it's a very hard thing to argue, because it just seems like the obvious answer is, if you're, oh, I messed up, you did it, right? So, man. All right, so let's do this analysis. Let's see. Oh, and good consideration. Kelly is like, my fear is now that Kayla's free, she will refuse to testify again. Well, if she continues, it seems like she had other benefits conferred to her for separate cases that don't relate to anything with Harmony. So if she's still finding herself in having run-ins and trouble, and she wants benefits in those cases, like promises not to prosecute, I think the state would very quickly run to leverage that to ensure her testimony at a retrial. But again, that's if she still finds herself like in a revolving door of getting herself in trouble. So, but yeah, very, very scary thought. Oh, goodness. Just crazy. This is a lot. So let's see. Let's get to it. We've got, the state contends that there was no such, did I read this first part? Yeah, this is the case law, noting that the state may gain an unfair advantage joining a weak case with a stronger offense. The state contends that there was no such risk because evidence of the July assault was presented separately, the offenses were discussed separately in the state's closing, and the jury was instructed to consider each indictment separately and not let a verdict of guilty or not guilty on one of the indictments influence its verdict on the other indictments. All right, we did the 1 and 2 already, so let's do, like, put an A in the chat if you're like, yeah, state, the jury will obviously separate this information. Put a B if you're like, what human mind works that way? Like, but that's always, the state will always argue, like, an instruction will cure the problem. The state argues that these cautionary statements are significant since juries are presumed to follow the instructions of the trial court. It's true, but this argument, just because you're following the instructions of the trial court and thinking, I'm not going to try to consciously consider something, doesn't mean you're not following the instructions of the trial court if your mind is just thinking things you can't help but think. So they say this argument is predicated on a more sanguine view of the efficacy of instructions to overcome prejudice than our decisional law supports. It also overlooks the misalignment of the instruction with the specific risk created by the denial of the motion to sever. Yeah, a lot of bees. A lot of with the actual buzz bee. Ah, love it. We got the all caps bees going here. Soap's like bee, duh. Yeah, I'd put a duh behind that too. I think the what's it called? The New Hampshire State Supreme Court agrees with the bees. They say it is true that we generally presume that jurors follow the trial court's instructions. Nevertheless, we recognize that there are circumstances in which that presumption is outweighed by the likelihood of prejudice, and that the jury could have found the defendant guilty of one charge, based at least in part upon the evidence regarding another charge. And they say this is State v. Mason, concluding that error in joining charges was not harmless. Here, as the case was presented at trial, the jury was asked to determine which of the two adults who were with the victim on December 6th and 7th, 2019. All right, so they did include like a variable window of time of death. The defendant or Kayla killed her. While the jury heard no evidence that Kayla had ever physically assaulted the victim, it heard evidence from multiple witnesses that the defendant physically assaulted the victim in July 2019. Thus, there was a significant risk the jury would draw the impermissible inference that because the defendant assaulted the victim before by striking her in the head, he must be the one who fatally assaulted her in December by again striking her in the head. And like the way my mind works, and it just pisses me off, but it's like I can picture a couple, and it's happened. There's been couples that have been jointly tried for abusing their children, and they partake in stuff like this together. So to me, it's not even just that it was Kayla instead, or one parent instead of another parent. If you guys are like this because you guys are living in a car, and if this is supposed to be happening every time this girl pees, and she's peeing because she's in a stressful situation, she's a child, she's not in her home anymore, she probably can't process what's going on the way we're reading it in like a legal document, why we had to move out of a home. And I have this image where I think it's possible that both parents would be partaking, and at the very least turning a blind eye if it's only one parent doing it. And it is really prejudicial for a jury to have the one parent, I mean, not the parent, girlfriend, because it's not even her biological child, because her two children are fine, get up there and say like he was bad to his kid. And maybe jurors are sitting there thinking like he wanted to be with Kayla so badly he didn't like his daughter from his previous girlfriend. Like there's just so much to have Kayla up there with immunity pointing her entire finger at Adam that I think is prejudicial. So, ugh. So they say that there's this risk of this impermissible inference where we're not just supposed to draw that because something happened in July 2019, something similar that ended up in a fatality happened in December. That's not evidence that that we're proving that this thing in December happened the way we're saying it happened. So they cite Bean v. Calderon, holding that concluding that joinder of charges arising from separate incidents allowed the jury to draw an impermissible inference of criminal propensity, which in turn allowed the jury to rely upon evidence in the stronger case to strengthen the otherwise weak case on other offenses. We conclude that under these circumstances, trying the second-degree assault and second-degree murder charges in a single trial jeopardized the defendant's right to a fair trial. All right, so this is the bit I read, like, this is where I started. This is where I started. And honestly, if you want to get like the reasoning real quick, you can search words like conclude and jump to like the summary of what the justices are finding. So this is where I started reading, and I'm like, all right, we're going to talk about this on a live. This just pissed me off, what we're going to read here. They say we do not agree with the state's contention, right? So the state made some contention in their reply to Adam Montgomery's appeal in opposing his arguments on appeal. This was an argument the state made. So the state contended that the trial court's instruction was sufficient to counteract the risk of prejudice to the defendant arising from trying the two charges jointly. The instruction said only that the jury must consider each indictment separately, and that its verdict on one indictment could not influence its verdict on another. Nothing in the instruction, however, told the jurors that they were prohibited from considering the evidence admitted on one charge when reaching their verdict on another. Which to me, that's like raise your hand, put a hand emoji in the chat if you've heard that instruction given in a trial before. Like, the evidence you're about to hear should only be considered for this, and then it's constrained down to one charge, one defendant, or maybe two defendants out of six. Raise your hand if you've ever heard that type of instruction. It's a standardized instruction. It's not like this unicorn. So this jury in this case apparently didn't get any of those instructions. So the instruction then left the jury free to consider evidence of the defendant's assault on the victim in July when deliberating on the second-degree murder charge. The state asked that we attribute significance to the defendant's initial motion for joinder, and this is where it gets worse. This is where I was like, what are we doing? The state asserts that the argument the defendant advances on appeal now was available to him when he made that motion, and argues that the defendant, quote, does not explain on appeal how any of the items in the state's Zwicker letter altered the analysis of that issue. The state contends that if the defendant's trial counsel could reasonably conclude that joinder under the circumstances was proper and in his client's strategic interest, it is difficult to see how a trial court's ruling one way or the other later in time could be clearly untenable or unreasonable to the prejudice of that defendant's case, and therefore an unsustainable exercise of discretion. So that's what the state was arguing. Here's what the Supreme Court responds to that argument with. They say, whatever the persuasive force of these arguments is in the abstract, without any context, the state conceded before the trial court. So before we go to trial, when the defendant raised this request, after agreeing to a joinder initially, then they get this Zwicker letter, and the defense is like, look, we actually want to separate. We no longer agree to this joinder. We don't want to do it that way after all of this. The state conceded at that point in time, when this issue was being raised in front of the trial court, that even if the Zwicker letter, in their opinion, provides no new information, which I think is disagreeable, it seems like it contained... they were providing information that Kayla deviated substantially from her prior statements. So I don't know how you could characterize that as not new information. But that's what they're trying to argue to this appeals court. They say then, the Supreme Court's like, the state also conceded that the defendant had the right to withdraw his assent to the joinder prior to trial, and was entitled to a fresh consideration of whether joinder was in his best interest of justice. So we hear on all these different appeals. If you guys follow appeals, if you're new to this channel and would like to follow appeals, come hang out with us. It's so interesting, and it's such a learning experience to read these filings. The idea that the state will frequently argue, oh, an appellant, a defendant, shouldn't be able to raise this argument. It was waived at trial. They failed to object, or initially they wanted it done this way, so they shouldn't be able to argue it now. Here we have an example where the state conceded something. They said, sure, that's fine. They have the right to do this. We don't argue it, which is a waiver of the issue. And yet they argued on appeal that, hey, you guys should just ignore that and give weight to the initial assent to the request for joinder. So it's such a role reversal. And I was reading this and I missed you guys very much, because I was like, the chat's going to be like, what are they doing? What are they doing? Why are they like this? So the state Supreme Court here is like, well, accordingly, the state disclaimed in the trial court the very argument it's trying to make on appeal. So they say, we're not going to consider on appeal an argument that the state waived in trial court. And then they cite here this case, Milliken v. Dartmouth Hitchcock Clinic. And they say that having determined that joinder of the charges jeopardized the defendant's right to a fair trial, we conclude that the trial court unsustainably exercised its discretion in failure to sever them. So, and then there's a little bit more. They dig at the state a little bit more here. They say the state nevertheless argues that even if the trial court erred by failing to sever the charges, that the error was harmless. Just a harmless error. To establish harmless error, the state must prove beyond a reasonable doubt, it's their burden, that the error did not affect the verdict. And also from another case from Rouleau, to determine whether the state has proven beyond a reasonable doubt that an error did not affect the verdict, we must evaluate the totality of the circumstances at trial. And so that's what you can evaluate, includes but's not limited to the strength of the state's case, which we saw previously in the opinion. The state Supreme Court's like, hey, we agree that the case for the assault charge is pretty strong, but we're not so sure about the strength of the case for the murder charge. 2, whether the admitted or excluded evidence is cumulative or inconsequential in relation to the strength of the state's case. 3, the frequency of the error. 4, presence or absence of evidence corroborating or contradicting the erroneously admitted or excluded evidence. 5, the nature of the defense. 6, the circumstances in which the evidence was introduced at trial. 7, whether the court took any curative steps. 8, whether the evidence is of an inflammatory nature. And 9, whether the other evidence of the defendant's guilt is of an overwhelming nature. And no one factor is dispositive. We may consider factors not listed above, and not all factors may be implicated in a given case. So we've got the parties agree that the state's case on the July 2019 assault charge was strong and rested on testimony from several witnesses without the credibility deficits that Kayla had. We conclude that the failure to sever the second-degree murder charge from the second-degree assault charge did not affect the verdict on the latter charge. So concluding that joinder of charges was improper, where the state's weaker case on some charges was bolstered by combining it with the stronger case on the other, so-called Casey counts. But concluding that given the strong and more than substantial evidence presented on the Casey counts, improper joinder was harmless beyond a reasonable doubt as it relates to the defendant's conviction on those counts. So because we conclude that any error with respect to the second-degree assault charge was harmless beyond a reasonable doubt, we affirm on the assault charge, right? So they're going through the charges. Now, let's see. Let's talk about the second-degree murder charge. The state argues that, likewise, any error with respect to joinder was also harmless as to the second-degree murder charge because the state's case and the evidence of the defendant's guilt were overwhelming. For the reasons discussed above, we disagree. The overwhelming evidence cited by the state, eyewitness testimony, testimony corroborative of the eyewitnesses, DNA, fingerprints, receipts, and the list goes on, related to the uncontested charges of falsifying physical evidence and abuse of a corpse. By contrast, only Kayla's testimony directly implicated the defendant in the victim's death, and evidence that the defendant stated that he hated the victim right to his core and that he fucked up are far from overwhelming evidence that he killed the victim. And they cite a case here that said concluding misjoinder was not harmless, where the evidence was not overwhelming as to any particular offense, and the case was dependent upon witness credibility. They say this is not a case, moreover, in which the jury found the defendant guilty on some counts and not guilty on others, which could have constituted compelling evidence that the jury considered the charges separately and was not influenced by the evidence of the other alleged offenses. We conclude that the misjoinder of offenses was not harmless as to the homicide charge. Accordingly, we reverse the defendant's conviction of second-degree murder. Now, this is interesting because we actually heard from Kelly, like jurors said, look, we didn't consider this prior abusive act when we decided he was guilty of the murder. But at the same time, when you're looking at it more from a procedural standpoint, especially if you don't have that information on the appellate record, you can't take that chance. And the state has to prove beyond a reasonable doubt that that did not occur, right? So, other act evidence. So then we've got, so this is why they reverse on the second-degree murder, and then now let's move into other act evidence. So we again address the defendant's remaining arguments because they're likely to arise again on remand. So as this goes back down, sending it back down to the lower court, we need to weigh in on this issue. The defendant next argues that the trial court erred in admitting evidence of certain prior and subsequent bad acts as intrinsic to the charged offenses. Specifically, he challenges the admission of evidence that he, quote, punched the victim in the 2 weeks prior to December 7th, 2019, and that he prevented the victim's mother, the actual mom, from having contact with the victim throughout the 10 months preceding the victim's death. All right, so there was a footnote. Let's read this footnote. In its order on the defendant's motion in limine, the trial court ruled that the state could introduce evidence of the defendant's conduct and the victim's condition in the 2 weeks leading up to and including November 29th, 2019, and between November 29th, 2019 and December 7th, 2019, a period of approximately 3 weeks. At trial, however, the only direct evidence introduced by the state of the defendant striking the victim during this period was Kayla's testimony that after the family began living in their car on November 27th, the defendant would hit the victim when she was incontinent in the car. On appeal, the defendant argues that the trial court erred in admitting as intrinsic evidence that he punched the victim in the 2 weeks prior to December 7th, 2019. Given the difference between this time period and the 3-week period referenced in the trial court's order, and in light of the evidence actually admitted at trial, we understand the defendant to be challenging only the admissibility of evidence that he struck the victim subsequent to the family's eviction on November 27th, 2019. So they're saying here that we express no opinion on the trial court's ruling with respect to any time before that date. So they're narrowing it down. What they're going to talk about here is from this November 27th to, or I guess, really we're dealing with November 27th through the 29th through December 7th. So let's see. Because it seems like the implication here is that technically there's a 2-day window that wasn't allowed by the court's ruling that maybe came in anyway. So let's see what they say here. That was a long footnote. Where was it? Where's the footnote? Oh, up here. Okay. So then they say, we review the trial court's ruling on the admissibility of evidence for an unsustainable exercise of discretion and will reverse only if it was clearly untenable or unreasonable to the prejudice of the defendant's case. So they cite the Rule 404B. So New Hampshire adopts the federal numbering system and just calls their same rule of like propensity evidence, bad character, 404B. So it prohibits the admission of evidence of a person's other bad acts for the purpose of establishing the person's propensity to act in accordance with character traits inferred from other acts. We have distinguished between extrinsic evidence of other crimes, wrongs, or acts, which is governed by Rule 404B, and intrinsic evidence, which is not. Other act evidence is intrinsic, and therefore not subject to Rule 404B when the evidence of the other act and the evidence of the crime charged are inextricably intertwined, or both acts are part of a single criminal episode, or the other acts were necessary preliminaries to the crime charge. So something like that would be like if you need to go purchase something to commit a crime, it's like intrinsic to the thing you're trying to do, even though it might not happen immediately at the same time. And then so intrinsic or inextricably intertwined evidence will have a causal, temporal, or spatial connection with the charged crime. Typically, such evidence is a prelude to the charged offense, is directly probative of the charged offense, arises from the same events as the charged offense, forms an integral part of witness's testimony, or completes the story of the charged offense. And honestly, I feel like whenever there's like not really a very definitive temporal, proximal, or like logical connection between two acts, the argument is always that it completes the story. We need to introduce this, we need to associate them as intrinsic acts because it completes the story. That's the argument very often we heard leaned on in the YSL trial. We've got the defendant argues that the December 7th, 2019 homicide did not depend in any way on the alleged abuse and neglect that previously occurred or on whether he blocked the victim's mother's contact with the victim beginning in April of 2019. Testimony on those matters, the defendant argues, was not essential to providing an intelligent and coherent description of what occurred on December 7th. The state counters, with respect to the prior abuse and neglect evidence, that the trial court correctly ruled that this evidence was part and parcel of the crimes charged, understanding that events do not occur in a vacuum. It completes the story. It contends that the challenged evidence completed the story of the victim's murder, which cannot be fully understood solely by recounting the events of December 7th, 2019. In particular, and I think I can picture this whole where they're living in the car and all this information. I can see that being a correct ruling, that it is relevant, it is part of the story. In particular, the state argues that the evidence allowed the fact finder to see the full picture and understand that this case was not the story of a loving father who unimaginably snapped under formidable circumstances. Yeah, I think the argument would be that he continued to snap and the snaps got more severe, or maybe you continued snapping at the same severity, but you hit at an angle that just ended up being fatal. Very sadly so. So I agree that, like, here we actually have a valid, in my opinion, necessary completion of the story. But in the YSL case, if you guys followed that, that was not always the case. So they conclude here that the evidence of other assaults of the victim during the time the family was homeless was intrinsic to the second-degree murder charge, in part because the conduct was an essential part of the course of conduct leading to the charged offense. So they cite State v. Wells. They also say the defendant concedes that this evidence bore an arguable temporal and spatial connection to the charged act, but argues that the requisite factual connection was lacking. And Papillon, this case here, says that while challenged statements by the defendant bore an arguable temporal connection to the charged offenses, without a sufficient underlying factual nexus, these statements are merely coincidental to the charged offenses. The court disagrees. So, in its objection to the defendant's motion to preclude this evidence, the state noted, albeit in the context of its Rule 404B analysis, that the prior conduct involved the same victim, an identical mechanism of assault. So we have two similarities here. We're getting mad and we're striking in the same area, the victim's face. It occurred under similar circumstances. We're upset about the incontinence, the pee in the car, right? So then we've got the challenge evidence described events that were a prelude to the charged offense and completed the story of the charged offense. This type of evidence is admissible under the rationale that events do not occur in a vacuum, and the jury has a right to hear what occurred immediately prior to the subsequent to the commission of the charged act, so that it may realistically evaluate the evidence. Evidence of the prior assaults gave the jury a more complete understanding of the alleged crime and better enabled the jurors to assess the likelihood that the charged crime occurred. And then they cite Wells and note that it discussed intrinsic evidence's probative value under a New Hampshire Rule of Evidence 403 analysis. So remember, Rule 403 is like the balancing. Is it more probative than prejudicial? Is it going to confuse the jury? Is it going to be cumulative? Do we already have something else that shows the same fact? Do we need this again? So all those, I love a Rule 403. I think we still have an emoji for it, right? We still have a 403 emoji. Another throwback. At some point in time, there's always a YSL reference when we stream over here. But there was a day where attorney Doug Weinstein lodged like 30 403 objections to the state to prosecutor Adrian Love in the YSL trial, and that was a good time. That was a good time. There we go. Here we go. So then we've got, let's see, the trial court did not unsustainably exercise its discretion in admitting this evidence as intrinsic to the second-degree murder charge. All right, so there we go. Let's see. They're saying that no. We're not going to agree with your argument, Adam, on this one. So when this goes back down on remand, the trial court already has like the pat on the back from the state Supreme Court here, like, your discretion, you used it well. You were fine in your ruling on that. And I doubt the state's not going to want to bring this stuff in. So this stuff will probably be reseen at a second trial. So with respect to evidence that the defendant prevented the victim's mother from having contact with the victim during the 10 months preceding the victim's death, the state argues that the trial court reasonably concluded that the evidence was intrinsic to the second-degree murder charge because it formed an integral part of the victim's mother's testimony and completed the story of her contacting law enforcement, and because it directly undermines the defendant's assertion that he dropped the victim off with her mother in November of 2019. Yeah, oops. So they say, we disagree that the evidence was intrinsic under either rationale. The evidence lacks a causal, temporal, or spatial connection with the charged crime of second-degree murder and is not inextricably intertwined with that crime. While the evidence may have explained how the victim's mother came to contact law enforcement, it neither completes the story of the charged offense nor forms an integral part of a witness's testimony about the charged offense. Now, personally, I would think that this is a way to explain why nobody has seen Harmony. right? So I think it's kind of necessary, but I guess maybe what the New Hampshire Supreme Court is saying here is maybe going back to the separation of the physical evidence and abuse of a corpse charges and the murder. I mean, maybe they're arguing that this doesn't isn't necessarily an intrinsic act to the murder itself. But to me, I think it very much relates to an understanding of why nobody was looking for Harmony during this time period, because people believe that she was with mom, biological mom. So, like, whoever else lived with Kayla or their friends group wouldn't be asking where Harmony was. I think it's kind of important, but the court here says they disagree. But in addition, we have never held that evidence undermining a defendant's asserted version of events that do not have a causal, temporal, or spatial connection with the charged crime is intrinsic to that offense. All right, so they've got case law. This has just been well established here in New Hampshire, that because it relates to a defendant's statement, how they're saying things happened, that gives this analysis. So they say, rather, we have considered the admissibility of such evidence under the rubric rule of 404B. They cite State v. Duquette, concluding that certain evidence was relevant for the non-propensity purpose of undermining the defendant's argument that she reasonably believed the alleged victim was about to use unlawful deadly force against her. All right, so there's a footnote. So this footnote is about this case that they're citing. They say the evidence was also of dubious relevance in light of defense counsel's remarks in his opening statement. Oh, wait, no, it's not. It's about this case. So this footnote's comparing it to this case. So we're back to defense counsel's opening remarks that Harmony died during the nighttime hours of December 6th and 7th, 2019, while she was in the car with Kayla and the other children. This contention implicitly abandoned the assertion that the defendant had returned the victim to her mother in November. Okay, so they're saying, like, look, we didn't even go down. This assertion wasn't made by the defendant at trial. So, like, the assertion being made to the jury wasn't this initial assertion that dropped the victim off with mom. But yet that's coming in later through the testimony. So the court here concludes that this evidence was not intrinsic to the charged offense. Therefore, the trial court unsustainably exercised its discretion in ruling to the contrary. So this one, they're going to agree with Adam Montgomery. They say this conclusion is limited to the determination that the challenged evidence is not intrinsic and does not preclude the state in a retrial from seeking to admit the evidence rule under 404B. So they say get it in under the correct analysis. Get it in under the correct analysis. So we might see that again at retrial. Of course, the state will have to raise their argument and the judge will have to make another determination. Then we've got a video encounter with the police. We've got the defendant next contends. See, I started this and I haven't drank my coffee and I'm just like, words are messing with me today. So get a little bit of energy going here. We've got the defendant next contends that the trial court unsustainably exercised its discretion in admitting a video of his encounter with the police on December 31st, 2021. By motion, the defendant succeeded in having his statements during that encounter excluded because he invoked his right to remain silent. And they cite State v. Remick here, notes that under the Fifth Amendment, use of pre-arrest silence in the state's case in chief, in which the defendant does not testify, is unconstitutional. He then moved to exclude all evidence of the encounter pursuant to Part 1, Article 15 of the New Hampshire Constitution, and the 5th and 14th Amendments of the U.S. Constitution, arguing that evidence that there was an encounter, with the substance of the encounter not admitted, merely raises questions and causes the jury to speculate and is therefore prejudicial. The trial court excluded only questions posed to the defendant, which resulted in his asserting his right to silence, and any assessment of his demeanor based on his asserting his right to silence. At trial, a video of the encounter was played for the jury without audio. So they're just showing him, like, in custody. I don't remember what trial was going on, because this was like 2024. So I believe I was watching the YSL trial while this was happening. Maybe that's why so many YSL memories are popping up in my mind today. But I don't believe I was streaming the YSL trial yet when this happened. Or maybe I was, because I think What got me so interested in covering the YSL trial was a plea deal. Was like these plea deal issues. I'm telling you, I'm like a moth to a light bulb when it comes to cases that involve plea deals for like a co-defendant or somebody else that could be a suspect. And it was at that point in time I'd seen YSL Tick or Slug testify. Trontavious Stevens is his real name. Testify about his plea deal and how he was held without bond. Nobody would get him a bond hearing for like 7-8 months. And then all of a sudden, when they wanted him to sign a plea, he could get out. He was no longer a risk. It wasn't safe. It wasn't unsafe to release him anymore, even though they never wanted to give him a bond hearing. He signs off on this plea deal, and he has to say that he will not testify truthfully at trial about the innocence of any of the other defendants named in the indictment. And I got mad and I did a video, and that was my first YSL video. And a year and a half later, I was still covering the YSL trial because it was so long. But I believe that's why I wasn't fully watching this trial, is because YSL had already started. So, yeah, and that's why the memories are overlapping there. It's a long time ago. Long time ago. So this video, what happened with this video? What does the court think about this video? And remember, if you're just tuning in now, the part of the opinion we're reading now isn't about the decision to reverse the murder conviction or affirm the other counts. This is just, now that this is going back on remand, where the state may and probably will retry on the second-degree murder count, here's some instructions for the trial court, right? We found an issue with one other act that was admitted. We didn't find an issue with another act that was admitted. And then now we're looking at a third issue, the admission of this police video where there's no audio, but it's showing we have some custodial, Adam Montgomery's in custody, and he had invoked his right to remain silent. So on appeal, Adam Montgomery, they argue that the video was improper evidence of his pre-arrest silence. He asserts that in the video, the police officers appear to pepper him with questions that he seems to answer, but that without the audio, the jury could only speculate about what was said. He then asserts that the jury could have understood from other evidence in the case that the police had located him that day to question him about the victim. He argues that because there was no evidence that he helped the police find the victim, the jury could only have understood that he did not cooperate, which constitutes evidence of his pre-arrest silence. Having reviewed the video, we cannot conclude that it could lead the jury to speculate about the defendant's pre-arrest silence. The defendant acknowledges that, as depicted in the video, the defendant seems to answer the officer's questions. Nor is there anything in the video suggesting that the officers were antagonistic towards the defendant or that he was fending off accusations. We are not persuaded that the video, without audio, constituted impermissible evidence of the defendant's pre-arrest silence. The defendant also argues that the video had no probative value or any issue of consequence. The state counters that the video was relevant and probative of the investigative steps taken by the police, and was probative of the defendant's whereabouts, who he was with, and his living situation when the police began looking for the victim, who was supposed to be with him. Based upon our review of the video, we conclude that while its probative value was slight, it presented virtually no danger of unfair prejudice. So they're like, we don't really know why the state really wanted to admit this, but we don't think it was bad either. But okay. Accordingly, we reject the defendant's arguments that the video is inadmissible under New Hampshire Rules of Evidence 402 and 403, and conclude that the trial court did not unsustainably exercise its discretion in admitting the video. So the conclusion, and if you're ever short on time, you guys, the conclusion is the great place to go quickly see, is something affirmed? Is something with or without prejudice? Is it just one count? Is it all of the counts? If you're ever short on time, this is the place to go, because I think sometimes headlines can read, it'll say like conviction reversed, but because it's not specifying in the headline what count was convicted, I think a lot of people could have woken up today, seen the news, and thought, everything is off the table. But really all that happened here, it's a big deal. It's not like all that happened means tiny, but it's only a reversal on the second-degree murder conviction. So they say, although the defendant requests that we reverse all of his convictions, his brief does not specifically address his convictions of falsifying physical evidence, witness tampering, and abuse of a corpse. To the extent the defendant does challenge those convictions on appeal, he's failed to demonstrate reversible error. Any issues the defendant raised in this notice of appeal but did not brief are deemed waived. So for the foregoing reasons, we reverse the defendant's conviction of second-degree murder, affirm his convictions of second-degree assault, falsifying physical evidence, witness tampering, and abuse of a corpse, and remand. So the second-degree murder will be remanded back down to the court. And again, we do have these three sets of guidance on these three issues should they be re-raised at the trial court level. So that's the opinion. It is linked in the description if you guys want to go take a look at it. They're still waiting to make sure it's completely correct before they formally publish it, which isn't unusual. It's like every first time an opinion comes out, they always have something like this at the top. And then, were you guys interested in looking at the oral arguments? I tried to upload them real quick. Yeah, I've got them processed. So I have the oral arguments processed if you guys want to watch those. It was, I think each side had 15 minutes each, and the whole video is 31 minutes and 45 seconds. So yeah, we'll watch that. Let me cue it up. Judy, I know the feeling. I don't know if you were used to my deep sighs. My sigh is like I don't know, a coping mechanism, I think is the phrase I'm looking for. When I go and I'll have a smile on my face when I do it. When I just go, it's here we go again. It's what else is new, right? And it is frustrating. It should be frustrating. And I don't really take offense when people are like, why are you so hard on the prosecution? Because when we watch trials, I yell at things the prosecution does, probably more so than the defense, although often I'm like, what are you doing, defense? Why would you not object there? But the reason for that is because when there's certain mistakes, this could be the result. This could be the result. And the best way to avoid it is to do it right from the start. So, good times. Let's get this up here. Very excited. The closed captions loaded in, because sometimes they take a while to cue in. And so this was argued back on October 15th of last year, of 2025. I just want to make sure it's not going to be too loud or too quiet when they speak. So play a little bit, hear their voices. I don't know why it looks like the lens on the camera is like greasy or something. They needed to clean it off before they filmed this. Let's see how they sound.
Please be seated. The Hampshire Supreme Court is now in session.
This case 2024-0304, State of New Hampshire versus Adam Montgomery.
Good morning. For the record, Justice Hans Marconi is disqualified in this case.
Seems choppy. I don't know if that's how the file was. Let me make sure.
And the reason I don't is because my recollection is out.
Unfortunately, we have a little buffer in the... I thought it would just be the camera that's kind of bad, but it seems like the audio is choppy as well. But in any case, we do have the argument, so I'm excited about that. I do like watching oral arguments, but it's always also a bonus when we have the opinion already, right? So now we're going to watch what they argue, but we already know the outcome. So we're going to get into it. I do want to say a big thank you here. Good vibes. Thank you for becoming a member, and thank you for hanging out with us. I've seen you in other chats. I don't know where, but I've enjoyed hanging out with you in other chats. It's been cool to have you here today, and thank you for becoming a member as well. And let's see. Yeah, this looks like when your glasses steam up. Oh my goodness. So let's see.
I did raise another issue in evidence. Second, the court erred in admitting as intrinsic evidence of other assaults in the weeks prior to the homicide and of blocking communication between HM and her mother. And lastly, these errors were not harmless beyond reasonable doubt. I did raise another issue in my brief, and I'm happy to answer any questions about those, but I'm going to focus on these. The principal concern with these issues is that a defendant be tried on the merits of the charged act and not on propensity and character inferences that may be drawn from evidence of other acts and wrongs. On the first issue, the cases simply should not have been joined for trial. They were not logically and factually.
All right, so for anyone that's not looking at the screen, it looks like the captions are doing a good job picking up on the parts that are cut out by the audio, which is cool that they're picking up on that. So if you're like, I'm missing some of the meaning of what's being said because of the audio, like it's choppy, it looks like the captions could help us. Also, Paula MC, thank you for becoming a member.
Actually connected in a manner that does not solely rely or demonstrate the accused has a propensity to engage in criminal conduct.
Does it make a difference?
Go ahead, Chief.
Does it make a difference that the defendant had joined and the state's assented to motion for joinder in the first instance?
No, I don't. And the reason I don't is because my recollection is that parties agreed to joinder early on in the pendency of the cases, and then as they neared trial, the defense moved to sever them for trial. The state did not contest that the defendant had a right to do that and to have the court look again whether it should be severed.
I guess my question is, if it was in the best interest of justice at the moment, the defendant agreed to join the cases, what changed?
What changed is I think through the as defense counsel said, through the development of the case in preparation for trial and additional information was coming out about how the state was intending to present its case. And defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are the Zwicker letters part of the record? Because I looked at the motion to sever, it references the Zwicker letters, but I didn't see them in the appendix.
No, they are not. But defense counsel talked about what was in them and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was perceiving the state's theory of the case going into trial, that this was going to be a trial about demonstrating a pattern of abuse. And that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial. And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly which witnesses were involved in those.
What's the significance of the two different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what...
In terms of this analysis, does the state of mind of the two different criminal acts have any bearing on our analysis for joinder?
I don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice. I think the concern when you join those two cases together in this case is that you have evidence of the July assault, which, as you note, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of Kayla Montgomery, and she had significant credibility problems. So to the extent that evidence came in through the joinder of these two cases for trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the defense's calculus with respect to the best interest of justice prong of the analysis, but that when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined? In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder, and so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness, or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as cases got towards the trial date, it was clear to the defense, as they made clear to the trial court, that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
I don't know if, I think over a year earlier is when the cases had gotten joined and started towards trial. I don't know at that point whether there was any written agreement or stipulation about evidence, or whether it was tied to the admissibility of other evidence in the case. And the other issue that I want to address this morning has to do with that ruling about some of the evidence the court determined was intrinsic. I don't think that was there was any agreement that tied the intrinsic evidence issue to the joinder issue.
So the admission of but you would agree, I assume, that the admission of this intrinsic evidence, assaults and abuse and neglect that occurred in the weeks before the murder, that affected the admission of this assault in July, that it made it compounded.
Correct. Yes. I mean, I think both issues are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at the joinder issue, to your point, the prejudice is not just to his trial on the homicide charge, it's also potentially to the trial on the assault charge, because as you point out, the intrinsic evidence came in as intrinsic to the homicide charges. And certainly it was there in the case for the jury to use in assessing both charges, the assault charge and the homicide charge.
So I want to give you an opportunity to address harmless error, but why don't you proceed with your second argument?
Yes. So with respect to the intrinsic evidence issue, there were two pieces of evidence that I focused on in my brief, and I believe it was error. They were not intrinsic to the homicide-related charges, which is what the trial court found. It was the assaults in the weeks leading up to the homicide, and then the bar of communication. With respect to the assaults, the state, even on appeal, says that those assaults, prior assaults, were necessary and essential to proving reckless intent on the homicide. That simply isn't the case. If you look at the state's evidence on the homicide charge, it's the evidence demonstrated, and the state argued that it demonstrated, that Mr. Montgomery acted recklessly by repeatedly punching HM until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
Doesn't it show the extreme indifference?
I think the charge itself shows extreme indifference. The evidence on the charged act, if you believe Kayla's testimony, that in and of itself is more than sufficient to establish recklessness. And I will also point out that this was not a mental state defense on the homicide charge. This was a defense that Mr. Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent on the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for intent, That's 404B evidence, subject to a 404B analysis. That's not an explanation for it being intrinsic to the charge.
Wasn't as the trial court noted, wasn't the jury entitled to some context about events leading up to December 7th?
I don't know why. I mean, context has to be tied to the actual the charged act. I don't know, and I guess this is a question for the state, but what about their evidence and proof on the homicide it has a hole or a gap in it that is impossible for a jury to understand and reasonably assess without having these prior assaults.
To Justice Donovan's point, your yellow light is on.
Yes.
And if you want to get to harmless error.
I do want to get to harmless error. I think that, as I mentioned before, the homicide-related charges rested exclusively on Kayla Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her trial testimony. She only gave that story after she had been arrested, jailed, and was facing additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened, and by the time she got to testify in this case, she was serving a prison sentence on perjury. She had significant credibility problems. The admission of all of this other evidence, either through the joinder of the July assault and the prior act evidence leading up to the the homicide, all of that rested on other evidence. And it gave the jury a reason to, even if they likely had substantial doubt about what Kayla said happened on December 7th, they could fill in that doubt by relying on the improper admission of the July assault evidence as well as the prior evidence leading up to the homicide.
Thank you, Attorney Phelan. You've reserved 2 minutes. Attorney Gagne?
Good morning, Your Honors. May it please the Court, Sam Gagne for the State of New Hampshire. Your Honors, the trial court committed no error when it denied the defendant's motion to sever, when it admitted intrinsic evidence, or when it admitted the body cam video. But even if it were to be assumed that the trial court did commit an error, any such error was harmless beyond a reasonable doubt, given the nature of the errors alleged in this appeal and the overwhelming strength of the state's case, which consisted of eyewitness testimony, numerous witnesses who corroborated that eyewitness testimony, and a mountain of physical evidence, the summit of which held only one conclusion, and the jury reached it.
Do you agree with the defense that the murder conviction rested predominantly on Kayla Montgomery's testimony?
Not necessarily, Your Honor. Certainly her testimony played a large part. She was the eyewitness to what happened on December 7th, 2019. There was no specific evidence to corroborate exactly what happened in that car as far as eyewitness testimony. But to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with the blood in the ceiling of the fit shelter, Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went to investigate and cut out that part of the ceiling, it was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the post-homicide actions of the defendant.
Sure, Your Honor. My ultimate point here is that all of these pieces of corroborating evidence of Kayla saying he hid her in the ceiling, he put her in the freezer at Portland Pie Company, he used a U-Haul to drive her and dispose of her body, he used lime to break her body down. If all of those things could be corroborated by physical evidence to show that Kayla wasn't lying about those things, it becomes a lot easier to credit her testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from raining blows on her face. That becomes a lot easier to buy once the rest of her testimony is credited, and very, very much of her testimony was. Again, through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing, and then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m., and he crossed back over going northbound at 5:25 a.m. The records show that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth, repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again. And that's even before we get to consciousness of guilt evidence of the defendant himself. He tells somebody on a jail call that the efforts to find Harmony's body is just a waste of taxpayer money. One could draw an inference from that yeah, I dumped that in a place you're not going to find it. Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls himself a close friend of his that he hated Harmony to his very core because Harmony reminded him of Crystal. That makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for the Superior Court's decision to allow the pre-December 7th abuse and neglect of Harmony in was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description. Do you recall?
So what I recall, Your Honor, is in closing, in final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence, or the July 2019 assault.
I do not recall that, Your Honor.
No, I didn't see it.
I do not recall that from the record. Speaking of, to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court recognized, wait a minute, my decision on joinder is somewhat implicated here. These are joined charges, and if the evidence of abuse and neglect starts to reach back into September, August, God forbid, July, these cases might start to bleed together. So if the joinder order is to remain a sustainable exercise of discretion, the court had to separate those enough such that the jury would be able to evaluate them intelligently and separately, and the trial court did that by limiting it as it did.
Can you respond to the defendant's argument that none of the evidence and that with respect to the 2 weeks prior to December 7th is material to the crime charge?
Yes, Your Honor. First, I note that Attorney Phelan mentioned she did not understand why any of that was important. The easiest way to respond to that before getting into the more substantive reasons is, as this court says time and time again in intrinsic evidence cases, events don't happen in a vacuum. This murder did not happen in a vacuum. The whole story is not told by simply recounting the event of December 7th, 2019. If that's all that is told, all you get is that in a vacuum. I'm not saying this would have been the defense or it could have flown, but you can start to maybe try to create the story that what happened there is actually a loving father, but he was under unimaginable circumstances, homeless, drug addiction, his children living in his car, no steady employment. He was under so much stress and he just snapped in the most unimaginable way. That becomes a much harder argument to even start making if you don't let this story be told in a vacuum, if you get the context. 3 weeks leading up to Harmony's death showed that the defendant did have extreme indifference to the value of her life. He did not treat her the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience, and that evidence showed that. Beyond that, as I kind of just wrapped up, it completed the story, and it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story, because again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible? What's the relevance of the Manchester Police's encounter with Mr. Montgomery 2 years after the murder?
So that does continue to tell the entire story of the case, Your Honor, because that is it's really the beginning of the story from the law enforcement perspective. That's how the investigation starts. That's the first interaction that law enforcement has with the defendant. It is relevant that when this is reported to the police, what they know is that Harmony is missing. And they say, okay, let's find the defendant because he has custody of Harmony. And it's relevant for the jury to know when the police located the defendant looking for Harmony, where was he? Who was he with? Harmony wasn't there. That's certainly relevant. There is relevance to that. Now, I'm not going to say that the probative value is through the roof on the body cam video, but it was relevant. And the reason it was properly admitted is because the risk of unfair prejudice did not substantially outweigh even small probative value. I contend that it was more than minimal probative value, but even if that's what it was, the risk of unfair prejudice did not substantially outweigh that. The prejudice that the defendant has set forth both in the trial court and in this court is really a tenuous risk of prejudice that is based on mere conjecture and speculation. This video had no audio. The defendant could not be heard. At defendant's brief, page 41, the defendant says the video shows the defendant seemingly answering questions. In that circumstance, and the defendant argues that the risk of prejudice is that the jury is going to infer somehow that he was not cooperative with police or that his right to remain silent was implicated. But the fact that there's no audio, he's shown answering questions, and that defendants carry into trial a presumption of innocence, there was no rational basis to speculate that the jury would take that video and just imply from it that the defendant was being not cooperative with police in that moment while they were just looking for harmony.
Was there any objection to the testimony about that encounter, separate and apart from the video?
I don't want to say definitively, Your Honor, but I don't believe that there was as I stand here, but my recollection of that is not good enough to answer definitively. Looking quickly to the severance charges, the severance issue, the state notes that, as Justice McDonald pointed out, that the defendant initially moved to join these charges and assented to a motion, and later had a change of heart, which he was entitled to do. The state notes that the case summary, which I don't know is part of the record, but the state could supplement if the court wished for it, seems to show an appearance of another defense counsel between the joinder and the motion to sever. And all of this is really to say that it seems odd that defense counsel at one point in time could have reached this conclusion reasonably and then changed their mind and perhaps reached a different reasonable conclusion, but then argues that the court clearly was unreasonable and untenable in reaching the same conclusion that they had reached earlier. Now, Justice McDonald also asked what changed. As the state argued in the trial court, as far as substantive information, nothing changed. What changed was that some of the stuff is now coming from Kayla. That it's lost on me, as Justice Gould pointed out, how that could impact the relatedness factors. Perhaps it speaks somewhat to the interest of justice issues, but it does not speak to the relatedness factors. Secondly, the July 2019 assault evidence, it's a little bit difficult to game this out because it's sort of hypothetical, but if these charges were severed, it's certainly possible, if not likely, that the July 2019 evidence could come into the murder trial under Rule 404B. Depending on what the defense and what the state of the facts were, the theories could have been modus operandi, lack of mistake, habit of the defendant in the way he disciplined the child, harmony, common plan or scheme. There's a number of theories that may have come in under anyway. The trial court may have been cognizant of that and thought that was another reason not to try the case twice. But even getting to the Brown factors themselves, the trial court's order is manifestly reasonable. If you go through the 5 factors, the state conceded and the court found there was no temporal and spatial relationship, so that pebble goes on the defendant's scale. The commonality of the victim and the defendant can't be disputed here. That clearly goes on the state's scale. The similarity in the mode of operation. In July 2019, the defendant gets angry at Harmony and he punches her in the face. On December 7, 2019, he gets angry at Harmony and punches her again in the head. I see my red light is on, Your Honor, and so we would ask the courts to affirm the trial court's orders and rest on our papers. Thank you.
Thank you very much, Attorney Gagne. Attorney Phelan, you have 2 minutes.
Thank you. With time, I will cover 3 points. Regarding the corroborating evidence, Justice Gould, the state answered your question and talked about substantial, in their view, substantial corroborating evidence. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct. And Mr. Montgomery at trial did not contest the charges and agreed to the charges of falsifying physical evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reasons herself and credibility problems to not be telling the truth about what happened. Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, to tell the whole story. This court has been very clear, whether it's talking about intrinsic evidence or 404B evidence, that those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity purpose. Evidence has to come in for context when it's necessary and essential to proving the charged act. The events leading up to December 7 in those prior weeks were not essential and necessary under the test this court has applied for considering whether it's intrinsic evidence.
Why isn't it relevant to whether the defendant snapped on December 7th?
Well, that wasn't the defense at trial. And until and unless the defense opens the door to that kind of evidence under that theory, it's not admissible. And as we know, as the trial played out, the defense was not that this was a lack of intent. The defense was he didn't do it. Thank you.
Thank you very much, counsel. Case is submitted. Court can recess.
All rise.
Right, so there we go. So that was the oral arguments, and of course the opinion we read at the beginning of the stream is the result of these arguments. So again, fear not if you're like, oh my gosh, this is horrible. Fear not. I have absolutely no doubt that the state is going to retry Adam Montgomery. Unfortunately, that's the way the process works. It's really sad to have to go through this. I can't imagine what any family members are going through. I also want to take a moment to shout out Judge Carol Erskine, who she said she wants to take today to speak with friends and loved ones, but tomorrow she agreed to go on with Defense Diaries to discuss this decision and the case at large. So I dropped a link to Defense Diaries channel in the chat. I don't see that they've scheduled, so I can't link directly to the stream that they're going to do. But if you want to look for that, it's going to be on Defense Diaries channel. And I'm also going to add a link in the description for Replay Crew to both Defense Diaries and to Carol Erskine, who is over on X, even though she doesn't have a YouTube channel. So if you're interested in that, check that out. I love Defense Diaries. I love Carol. I think it's going to be a great conversation. And I'm sure, as you guys in the chat are already sharing, you guys are looking forward to it. With that being said, I also want to say thank you to Tara here becoming a member. Thank you so much. And also, I actually bookmarked, I believe you mentioned in the George Pino trial, hey, if there's issues with signals, could there be an issue with the signal for the GPS tracking? Could that affect the GPS? And so I bookmarked that. This is the George Pino case that trial's underway now. We've been streaming that live every day. When I get on with Bob and Allie from Defense Diaries, I actually want to talk about that and a video someone else sent in of their own boat with how their GPS works, and it does show channel markers. And I think it's really, really cool with the way that we can watch trials online, that we can bring this information in together. So thank you for the super. Thank you also for sending in that insight. I do have it pinned for our discussion today, which starts in like 20 minutes. So let's see. Any questions from you guys in the chat? We have Brittany saying, I think it's plausible that Kayla did it and he helped cover it up. And I think that's why it's an issue, is because Kayla's credibility, at least when it comes to the second-degree murder charge, the day of the murder, there isn't really much there to corroborate her statement. So if she has this huge credibility issue, and she is the evidence that can go to prove that murder, like direct evidence, it's her testimony, that's a problem. And now what do we do? What do we do? The state's going to retry. And I mean, they should be able to talk about all the stuff that happened after the fact, because he's actively presently still convicted of those things, right? So the state's still going to go through all of the motions to talk about, like, he's trying to keep the body in a bag. He's going and making these purchases to get equipment for this cover up. I think that stuff is so compelling, even though it is true that somebody might only be participating in the cover up aspect. I still think that's very, very, very compelling evidence for a jury to unanimously conclude that somebody also participated in the underlying murder, right? So I think this is still valid. And I don't know, is it Bees girl? Buzzin' girl, maybe. Buzzin' H girl. I'll get it right. I'll try like 10 variations till I get it right. The issue is now that Kayla's not in prison, so will she testify if they can find her? Now, if she has frequent run-ins and she gets in trouble again, I think the state could pretty easily, maybe, if she's continuing to get in trouble with the law, find themselves in a position where it'll be the same old scenario where you're facing a prosecution for a different matter. If you want leniency in that, we need you to cooperate and come testify and do what you did the other time around. So if they have trouble locating her, that would be a problem, but I would imagine they'll put all resources out and really be trying to locate Kayla, right? Sometimes I've criticized prosecutions in other cases where it doesn't seem like they tried to look for a witness that could be helpful for the defense. But here, I don't think they have any reason to not do a full-on diligent effort to try to find Kayla, and I hope that they do so. So, let's see. Yeah. Raylel says, this is a horrible day. The state has to do better. Better be a lesson learned. Better be a lesson learned. Linder Lou the Sous says, are you a sous chef? Because that's very cool. I watch a lot of Chopped. Very interested. Chopped, by the way, since we're speaking about true crime, Chopped is like a cooking show. But if you're a sous chef, very, very cool. I don't think I could do something like that. I cook very slowly. Very, very slowly. Like SpongeBob making one single Krabby Patty while King Neptune makes 1,000. I can't do the time management with that. So, but Linder says, can they come back and charge her for murder? So I don't know the exact extent of the immunity agreement, but typically it would be like they can't use any information that she was given immunity to provide for the prosecution against her. So they'd have to find a new way to do so, new evidence. And you know, maybe that could be Adam Montgomery deciding to give a statement that hasn't previously been available. But would that be credible? Right? So then the state would still be in a pickle where now you've got 2 less than credible witnesses. But typically they wouldn't be able to use anything that she's already been covered for as the pathway to say, look, we're actually thinking you are the suspect and we want to charge you with that information that we previously had and gave you immunity for. So technically, yes, but I think it's highly, highly unlikely. So Tara says, thank you for the 5. Says also the changing anchor spots due to larger boat. This is George Pino, you guys. He would likely know where he was from the original spot, but moving affected situational awareness. Guys, there's this trial going on in Florida, the George Pino trial, and it's about a boat crash. And I'm not familiar with boats. And we're about to be on day 4, and we really haven't had somebody like tell us about this particular boat, how the boat works. We've heard a little bit about how a channel works, but commentary was challenging what this witness was saying about how channel markers work. So we're like watching this trial about a boat crash, and I just don't feel like the state's doing a very good job giving us framework to work with on here's the actual like lay of the land and the equipment, the boat that's at the subject of this trial. So that's what Tara here, she has some great insight and some great questions about what's going on with this GPS. You know, the positioning's very important. What was the angle of the impact? And it's like, I'm not sure that the state knows or even really looked at this information. So I'm going to screenshot this. We'll talk about this as well when we get together with Bob and Allie from Defense Diaries for day 4 in about 15 minutes here. It's okay. It's okay. We get off topic here. And again, like that's me criticizing the state because there could be if you point these things out and you say, look, there's no way you have this equipment on your vessel. There's no way that you should miss this thing. You are culpably negligent for crashing into this. There's no excuse. Then you can get the conviction. The prosecution makes sense. If not, then maybe the state's overcharging with this manslaughter that they brought against George Pino. And maybe it would have been more appropriate to charge something less if they don't actually have this information, or this information causes a problem for their theory. And it's like, I can't tell. I can't tell because the state isn't presenting this stuff. So, again, I don't see why they don't just present the case as you have it, look at the information available to you. The state, I think George Pino is well off and has a great defense team. But generally speaking, the state is usually better situated with resources and a quicker point in time because they're connected with the arm of the state, the law enforcement, to be able to do the investigation, to send subpoenas. People feel like they need to talk to police officers, to investigators that come to them. And those investigators may say, hey, the defense might try to speak with you, but you don't need to speak with them. So there's access issues for a typical defendant to try to get their hands on the same information that a prosecutor is able to get their hands on. And because they have the increased access, my position is do the research, do the legwork, make sure you do your due diligence to put your case together, because you could end up in a situation where you might really be charging the correct thing, but you're wholly failing on your presentation of it in front of a jury. And then you don't get the outcome that maybe should be gotten. So we're still in the middle of trial for George Pino. I don't know how that will play out. But I gripe about the state all the time over here on this channel. I just do. Oh, and yes, okay, so you are a sous chef. Okay, I never pronounce anything right. So guys, I pronounced the name right today. Hallelujah. So there we go, guys. I've got to wrap this up because I'm gonna, I don't know, my coffee, my ice melted. I don't want it anymore. Gonna get some ice water and get ready before I jump on with Bob and Allie from Defense Diaries. If you're watching live, this will redirect over there. If not, if you want to jump over and see what's going on with this boat crash trial down in Florida, because where else, of course, check out, just go to the channel, go to the live tab, and look for George Pino Day 4. So see you guys over there. And remember, tomorrow, Defense Diaries, I don't know what time, but should be getting together with Carol Erskine to continue talking about this case, which I think will be a great conversation. So thanks for tuning in. See you guys next time we run into each other, and hope everyone has a good one. See ya!